everyone. This is Jennifer Schaus coming to you live from Washington, D.C., and we're continuing in our Webinar Wednesday series. Thanks for joining us. Today, Bryan King is going to be talking about the return on investment or not in bid protest. Next week, we will discuss at 12 o'clock 7 steps to capitalizing on federal government Q4 contracts. And then at 12:30, we are covering resubmitting a rejected GSA schedule proposal. So our webinars are every Wednesday at 12 o'clock and 12:30, and our speakers range from accountants, attorneys, industry experts, and consultants who have some knowledge and are sharing their knowledge and information about government contracting. The webinars are complimentary. They're recorded. You can find those on our website under the webinar section or under our YouTube channel. If you do have questions for Bryan, his contact information will be found on the last slide. You can contact him by phone or email. And a quick blurb about us. We are based in downtown Washington, D.C. and provide professional services for government contractors, both product and service companies, domestic and foreign firms, small, mid-size, and large businesses. Our services range from market analysis reports to contract vehicles, including GSA schedules, contract compliance, and more. We do host events and seminars throughout the year, and you can find those on our website under the event section. Some of the latest events that we have coming up are some GSA schedule classes and 2 construction conferences, one in Fairfax on September 13th and one in Austin, Texas on November 13th. A little bit about our speaker today is listed here on this slide, Bryan King. He's a partner at Offit Kurman law firm, and I think he is joining us today from his Tyson's Corner office. And we will get started, so I'm going to hand the floor over to Bryan. And thanks again, Bryan, for joining us, and look forward to hearing your presentation today.
Thank you, Jennifer. As Jennifer mentioned, I'm a partner at Offit Kurman, and I focus my practice on federal procurement. Basically, I assist government contractors in all of the various issues that arise as they're pursuing federal government contracts. And one of the issues that comes up quite a bit is the issue of, do I protest? There are certain questions that need to be considered by any contractor when they are determining whether or not it makes sense for them to protest. And so these are the questions that I go through with my clients when we're going through this process, and so we're going to talk a little bit about those today. Next slide. So there are, I've put here 6 key questions that need to be considered. There are probably many more questions that are within these 6 questions, but these are the 6 basic questions that I come across when I'm talking with my clients about whether or not to protest. Do you qualify? Do you have valid grounds? Is an automatic stay an option? How important is this contract, or how important is this agency to your company? What is your relationship with your customer? Is that going to affect your decision? And then, if we do want to file a protest, what forum makes the most sense? So let's get into these questions one by one. So before we do, some basics on protests, just to make sure that we're all on the same page. There are 3 primary bid protest forums that we're going to be talking about. There are agency-level protests, which are filed with the contracting officer and generally decided within 35 days of the protest. Then there are GAO protests, which are by far the most common protests. Those are usually decided within 100 days. And then there is the only court option that we have for bid protests, and that's at the U.S. Court of Federal Claims. Next slide, please. And then there are 2 main types of protests. There are a few that don't quite fit neatly into either of these boxes. For example, if you're challenging your exclusion from a competitive range, technically that's challenged before an award is made, but it's not technically a pre-award protest. But for the most part, we are dealing with 2. We're talking about pre-award protests, which challenge the terms of a solicitation or the ground rules for a procurement. And then there are post-award protests, which challenge the agency's evaluation or the agency's award decision, their best value determination, that sort of thing. So with those basics behind us, let's get into the questions that we need to ask ourselves before we decide whether or not we want to protest. first, do we qualify? That's the first hurdle that we need to clear, because if we don't qualify to protest, none of the other questions really matter. So the initial hurdles that we need to think about are, do we have standing? Are we timely? Is the issue we want to protest even protestable? And if we're protesting a task order, is there jurisdiction to file this protest? So next slide, please. Let's talk about each of those individually. So standing, you must be an interested party in order to file a protest. So basically that means that you are an interested, you're an actual bidder on the contract, or if it's maybe a pre-award protest, you are a prospective bidder on the protest. And in some cases, for pre-award protests, you actually still need to submit an offer, a timely proposal, in order to preserve your standing to protest. Otherwise, you might not be an interested party. But for the most part, you are a contractor that has some economic interest in whether the contract is awarded. And then there's timeliness. Every protest forum has its own rules on timeliness. For agency level protests, if it's a pre-award, it has to be filed before the due date for proposals or bids. If it's post-award, within 10 days of when the protester knew or should have known. GAO protests, it's the same as agency. For pre-award, has to be filed before the due date for proposals or bids. And post-award, within 10 days of when the protester knew or should have known of the grounds of the protest. Or if it's a protest that has a required debriefing, the protester can file within 5 days of that required debriefing, whichever date is later. And keep in mind that these deadlines are pretty hard and fast. With very rare exception, untimely protests will be summarily dismissed by GAO and the agencies. One common mistake that I see a lot with pre-award protests is that protesters will wait until after an award to try to protest the terms of an RFP. Basically, they kind of want to see how things play out before we decide to protest. But if you file a challenge to the terms of the solicitation after an award is made, or after the due date for proposals, that's going to be dismissed. And then the Court of Federal Claims, there's no set time limit there. For pre-award protests, they basically follow the same rules. Has to be before the deadline for receipt of proposals. And then for post-award protests, needs to be within a reasonable time. There just can't be any serious delay in filing the protest. So next slide, please. Next is the issue protestable. There are some issues that can't be challenged in a bid protest. Issues of contract administration. So, if a contract requires the awardee to get some certification, you can't protest whether or not the awardee is going to be able to get that certification. That's a matter of contract administration. That's between the agency and their contractor. So GAO or Court of Federal Claims, they're not going to hear that. You can't challenge the responsibility of the awardee. You can't challenge the awardee's size or status. Those are issues for the SBA, although, for the size or status of the awardee, there might be an option to protest at the SBA challenging those, but that's a separate protest discussion. And then protests of task and delivery orders. If you're protesting a task or delivery order, generally there is a prohibition against these protests with two exceptions. At either GAO or Court of Federal Claims, you can protest, you can challenge that an order increase the scope, period, or maximum value of the underlying contract. And then you can also protest orders over certain dollar thresholds. So at DOD, you can protest task orders over 25 million, and civilian agencies, you can protest task orders over 10 million. And these protests have to be filed at GAO because GAO has exclusive jurisdiction. So anything that doesn't fall under one of these exceptions, if it's a protest of a task order, there's just really nothing you can do. Next slide, please. Okay, so now that we've decided that we do have grounds to protest, that we do have the ability to protest, we're qualified to do so, then we have to decide if we have valid grounds to file a protest. Now, this depends on each specific situation, but there are some grounds that are fairly common that lead to successful protests. So for pre-award, you can, if the terms of the solicitation are ambiguous, if they're overly restrictive, maybe there's a specific brand name requirement in the solicitation that's unnecessary. We've all seen procurements that are obviously wired for one contractor, so there could be terms in there that make it very clear that it's unfairly favoring one offeror over everybody else. It could be a situation where you believe the contract should have been set aside for small businesses, but the agency failed to do so. You can protest that. And then sometimes there are contract clauses that just don't apply to the solicitation. So it's best practice for contractors to try to resolve these issues through the Q&A process if possible, because sometimes agencies will include terms in a solicitation by accident. Either it's a leftover from the previous contract or it was cut and pasted from somewhere else, and they didn't realize that not all of it applied to this particular procurement. So sometimes, through the Q&A process, you can get an agency to amend the solicitation to fix these sorts of issues. But unfortunately, that doesn't happen every time. So, pre-award protests may be the way to go. Next slide, please. So as far as post-award protests, again, depends on the specific situation. And for the most part, GAO and the court will defer to agency's discretion on a lot of these decisions, as long as the agency's decision is not arbitrary, capricious at the Court of Federal Claims, or just very unreasonable. It's going to be difficult to overcome. But there are some grounds for post-award protests that do lead to successful protests. So any deviation from the solicitations criteria that affected the award, that could be a successful protest. Challenges to the way that the agency evaluated price, or the way that they evaluated the technical proposals, the evaluation of past performance, the way that they calculated the cost could have been incorrect. And for a best value procurement, the manner that they conducted their cost technical trade-off could have been improper. Maybe they just made an award to the highest rated offeror without even really considering any of the other offerors. That's an improper cost technical trade-off. If there were discussions, there could be an argument that the discussions were improper, unequal, and misleading. And then also, if one of the offerors was mistreated, that could be a successful protest ground. But for post-award protests, the best practice here is for contractors to use the debriefing process to gain as much information as they possibly can in order to determine if their grounds are valid. So next slide, please. So since, as I mentioned, debriefings are a way for contractors to gain information about possible protest grounds. So let's talk a little bit about debriefings. They're only required in FAR Part 15 procurement, so it's a negotiated procurement, or other procurements where it explicitly states that FAR Part 15 procedures are going to be used. So you see that every now and again with commercial item procurements. And then any task order over $5.5 million, there's a requirement for a debriefing. If a debriefing is required, the offeror is required to request it within 3 days of either learning that it's been excluded from the competitive range or receiving notice that an award was made, and obviously it wasn't the awardee. In a debriefing, the agency is required to identify any weaknesses or deficiencies in the protest proposal, the evaluated price and technical rating of both the protester and the awardee's proposal. And then if there was a ranking of offerors, that needs to be disclosed as well. They also need to provide a rationale for their award decision, and then reasonable responses to protesters' questions regarding the source selection decision. That's the response. Providing responses to protesters' question is a requirement. Agencies will try to get out of that sometimes, but it is something that they are required to do. Now, I always tell my clients, always request a debriefing, even if one is not required. because a lot of times, even if it's not required, agencies will provide information in a quote unquote debriefing, because for protesters, getting that information is valuable because it allows us to formulate protest grounds. But sometimes it does provide information that says we shouldn't protest. We don't have any valid grounds. What the agency did here, we may not like it, but there's really nothing that we can argue. Now, also it should be noted that the DoD recently made some pretty big changes to their debriefings, their enhanced debriefings, which basically, under their new rules, debriefings are going to be required for all contracts, whether or not it's negotiated, and then any task order over 10 million. And then in certain procurements, the agency is going to be required to actually disclose copies of the source selection documents. Now, these are going to be redacted copies, but still source selection documents nonetheless, which will be very interesting. Next slide, please. So the next question that we're going to want to ask is an automatic stay available? Now, this is important for the procurement process because essentially it allows bidders to maintain the status quo pending the resolution of a protest, so that if a protest is successful, that the protester still has the opportunity to receive the award. But it's most important, really, as far as protests are concerned, for the incumbent contractor, because if a stay of performance is implemented, most of the time the company or the contractor that is currently performing is either going to get an extension of their contract, or they're going to receive a bridge contract so that they can continue to perform while the protest is resolved. And sometimes this might be 100 days if it's a GAO protest, or in some cases, agency might take corrective action, or if the protest is sustained, the agency may need to go back and reevaluate, or do a lot more procurement planning or something, and that could draw the bridge contract or the extended incumbent contract out even further, which is obviously great for an incumbent contractor. So, if you're an incumbent contractor, this is obviously something that needs to be considered when you are determining whether or not to file a protest. You still need to have viable grounds to file a protest. You can't just protest just for the sake of the stay. But this is very important to consider. Next slide, please. Okay, so this question is specific for every company, specific for every contract and every agency. Sometimes there are reasons outside of the specific contract at issue that a protester might want to protest. There could be, well, first, one of the things to consider is how much money are you expecting to make out of this contract? Because it may not make sense to incur the expense of a protest to win a contract where you're not really expecting to make a lot of profit. Now, there is a chance, if you're successful in a protest, that you'd receive the cost of filing that protest back from the agency, but that's not a guarantee. So, the expected profit is definitely a consideration to make. So sometimes it might not make sense to file a protest on a, $3 million procurement or something like that, because the cost of filing the protest just will exceed any profit that you might expect to receive. But as I was starting to say a second ago, sometimes there could be other factors that you would want to consider when you're making the decision to fight for the award. Sometimes you just really want to get in with an agency. You believe that winning this first protest will lead us to getting, or winning this initial contract will lead us to winning more contracts down the road. We just need to get in there. Sometimes you're concerned about growing the company, increasing the number of contracts that you have, whether it's, as some part of an exit strategy, or if you're just, trying to grow, it may make sense to fight for a contract. You might want the particular past performance that you would gain out of the contract in order to increase your viability for other contract awards. Or maybe you're just trying to move into a new NAICS code. There's a secondary NAICS code. You're trying to win some contracts in. Maybe it's got a bigger size standard. You're trying to move over there for small business purposes. There are a lot of different factors that could come into play, but this is something that you need to consider before you decide whether or not to file a protest. Next slide, please. So the next question is, what is the relationship with your customer? Will be, again, specific for each contractor. But I will say that there are very few times that I have discussed protests with a client where they did not bring up, well, what's the agency going to think about this? Are they going to get mad at us for filing this protest? The procurement system is really designed to eliminate any sort of bias in making decisions on who to make the award to. So concerns over protest retaliation are probably unfounded. And a lot of the agencies are very familiar with the protest process and will often pad their procurement time to include any potential protests. But at the same time, we know that agencies are run by people, and people sometimes, let biases sneak in even if they're not supposed to. So it's something that needs to be considered by every contractor in deciding the protest. But, the good news is that protests do not need to get personal. It's very easy to avoid any allegations of fraud or bias. You can keep things, very specific. The solicitation said that you were going to do X, you did Y. That's not proper. So we just want that to be fixed. But this is a business decision. Every contractor knows their customer best. You best know how that relationship goes, and this definitely needs to play a part in whether or not you decide to protest. So last question, if we are moving forward with a protest, what is the forum that makes the most sense? Do we want to go to the agency? Do we want to go GAO? Do we want to go Court of Federal Claims? Each of these has pros and cons. I will say, for the most part, agency level protests are really only limited to protests where either you don't think you're going to win at one of the other forums, but you feel really strongly about this issue, so you want to raise it with the contracting officer. Sometimes it makes sense if you have potential contracts for this agency down the road, and you just want to raise this issue now so that it doesn't become an issue later on. But the problem with agency level protests are there are no published decisions, so we have no idea how different agencies see some of these issues. And anecdotally, I can tell you that agency protests very rarely win. So GAO protests are by far the most common. They have a very large body of case law, so it's very easy to find support for protest arguments. They're very familiar with the procurement process, and they have a fast decision process. It's 100 days, and then you also get that stay of performance, which is very beneficial. One of the cons, as I mentioned earlier, the record in a protest is limited to what's raised in the actual protest, so that could be an issue if you want to possibly see, how the agency treated the awardee. Then there's the Court of Federal Claims. It's a very, very robust record. The court wants to see everything related to the award of the contract, whether or not it was challenged in the actual protest. So that's a very big pro. And if it's a complicated issue that you feel is better explained in a hearing, you're more likely to get a hearing at the court. And you generally have more time to file because they don't have the short 10-day deadlines. The cons, no automatic stay. You have to request an injunction, which just adds to the cost. And again, the court, generally the most expensive option. I think last slide. Yeah. So those are the questions that you want to go through whenever you're considering whether or not to file a protest, whether it makes sense. But because protests at GAO are by far the most common, I thought it would be helpful to kind of include some of the stats from GAO protests. As you can see, over the last 5 fiscal years, which is the most recent data that we have, approximately 16% of protests were sustained by a decision. So obviously that's a very low number. But when you consider the number of protests that resulted in the agency taking corrective action, about 45% of protests resulted in the protester receiving some sort of relief from their protest, which, it's definitely a consideration to make because agencies take corrective action quite often. But one thing, and I'll end with this, one thing to keep in mind: winning a protest does not necessarily guarantee success as far as winning the contract is concerned. Sometimes you win the protest and you still lose the contract. That's just sort of a fact of the process. So that concludes my presentation on bid protests and the questions that you want to ask on whether or not it makes sense. Thank you, everyone, for listening. My contact info is here. If anybody has any follow-up questions, I'd love to hear from you. Well, thank you very much.
Thanks, Bryan. Excellent information on bid protests today. Both recordings will be available on our website under the archive webinar section by the end of the week. They'll probably be on our YouTube channel by this evening. Next week, we are covering 7 steps to capitalizing on federal government Q4 contracts, as well as our 12:30 session, which is resubmitting a rejected GSA schedule proposal. So thanks again, Bryan, for the great information, and thanks again, everybody, for joining us today.